Yeah, I'm glad you brought this up, Greg, because and particularly the legislative intent, because I just came across a case law in South Carolina that goes to the legislative intent of Title 4D. So I appreciate you pointing that out.
It's in yellow now, I think.
Give me the cardinal rule of statutory construction is to ascertain and affect the legislator. Skipping the case law. Under the plain language, under the plain meaning rule, it is not the providence of the court to change the meaning of a clear statute. Where the statute's language is plain, unambiguous, and conveys a clear, definite meaning, the rules of statutory interpretation are not needed, and the court has no right to impose another meaning. Like the Court of Appeals, we do not construe Section 12-20-21 to have the plain meaning attributed to C.
That clear, was it clear? A clear, definite meaning where the statute's language is plain, unambiguous, and conveys. Yes.
A clear and definite meaning.
Is that helpful to a lot of guys when we're talking about, instead of focusing on what doesn't it make sense that we should focus on what as it relates to your facts? And I believe that was a market like Marcus told us.
Hey, question, Greg.
Yes, sir.
And this is based off curiosity to Florida statutes, and then you went through.
Yes, sir.
In Florida, where the agency is supposed to notify the other party of the.
I don't know that for sure, but I do know that you could get a copy of the application because I've done that. So to answer your question, you're talking about the child support case. Like when I asked the attorney that Miss Smallwood filed that application in Florida, and she said, yeah, before I asked her. And what's one of the rules we have? Don't ever ask a question unless you what?
You don't want to answer.
So I don't know, but I have all the applications last, I want to say since, I can't remember. I have like 8 or 9 different applications for services. And so when I used to tell people I had an idea of, when you talk about, what is it? Failure to make a claim, state a claim for which relief can be granted. Well, the application just ascertains information, but the information has never been, most people don't cross-examine the information on the application because you don't see the application. The question may be, and I don't know what the rule would be because, I'm so far removed from this stuff now, as to what on the application gave rise to the mother having a claim for anything. Nobody's arguing that parents shouldn't take care of their children. That's a different argument. But what in this specific application gave rise that she was entitled to anything? Is that clear?
Very clear. Crystal.
Okay, so there we go. So we're in Florida now. We'll save Florida last. Care about that. And by the way, I had to explain, I've done this so much now. So, you kind of learn how to, the more you do anything, like any muscle, you become better. So even when it comes to